Every breach of contract entitles the injured party to claim damages for the loss caused by the breach. The purpose of an award of damages is simple: to put the injured party in the position they would have been but for the breach of contract. The law has traditionally used two measures. One protects expectation interests and the other protects reliance interests. A restitutionary measure is calculated by reference to the defendant's gain rather than the claimant's loss. Two devices limit an award of damage. The first device is remoteness. There can be no recovery of losses which are too remote, that is to say, losses which are not foreseeable. The second device, used to limit the recoverability of loss, is mitigation. It is said that a party cannot recover damages for a loss that he could have reasonably avoided. A party cannot recover damages for non-financial loss, such as injured feelings or distress arising as a result of the breach of contract. The purpose of an award of damages is to compensate the injured party and not to punish the party in breach. See, for example, Raxley Electronics versus Forsyth from 1995. While the purpose of the award of damages is to compensate the claimant, the difficulty of assessing damages will not prevent their recovery. See Chaplin versus Hicks from 1911. The claimant will not, however, receive damages where the breach of contract has left him no worse off. See C&P Hollage versus Middleton from 1983. Damages are normally assessed at the time of breach. Expectation loss. This is the basic measure of contractual damages. This loss is summarized in Robinson versus Harman as follows. The rule of the common law is that where a party sustains loss by reason of a breach of contract, he is, so far as money can do it, to be placed in the same situation with respect to damages as if the contract had been performed. The purpose which the expectation measure of damages is meant to fulfill is that if the contract created certain expectations of performance and that those then failed, the innocent party is to have these expectations fulfilled through an award of damages. The compensation is thus for disappointed expectations. In situations where the defendant does not perform the contract or performs it badly, the claimant is generally entitled to the cost of cure. See Watts versus Morrow from 1991. In some instances, however, the courts will not award the cost of cure where this is wholly disproportionate to any benefit which would have been received. In these circumstances, courts will award damages for the loss of amenity. See Raxley Electronics and Construction versus Forsyth from 1995. Reliance loss. An alternative basis on which to assess damages is the reliance of loss or the loss of expenditure. This basis is usually used when the claimant is unable to prove that the financial benefit would accrue to it had the contract been performed. Anglia Television versus Reed in 1972 is an example. The claimant is the party who decides whether to seek his reliance losses or his expectation losses. See CCC Films versus Impact Films from 1984. The claimant cannot, however, seek to recover his reliance loss where this would have the effect of allowing him to escape the consequences of a bad bargain. See C&P Hollage versus Middleton from 1983. Restitution. Recovery on a restitutionary basis will only occur where the claimant can establish that the defendant was enriched at the claimant's expense and that it is unjust to allow the defendant to retain his profit without compensating the claimant. A restitutionary award requires the defendant to disgorge the profit obtained as a result of his wrongdoing. A claimant may seek a restitutionary remedy where there has been a total failure of consideration. See Wincup versus Hughes from 1871. A second set of circumstances occurs where the claimant seeks a restitutionary remedy on the ground that the defendant has obtained an unjust benefit or profit because of his breach of contract. The House of Lords has now held that the court would order an account of profits where neither equitable remedies nor an award of damages based upon a financially assessed measure of damages would provide sufficient remedy. See Attorney General versus Blake from 2000. English courts will not allow payments in the form of penalties for breach of contract. What are allowed instead are known as liquidated damages. In Dunlop Pneumatic Tire vs. New Garage from 1915, the House of Lords confirmed that the liquidated damages clause is enforceable provided that the amount is a genuine pre-estimate of the damage and not unconscionable. In Cavendish Square Holdings vs. McDessie from 2013, the court observed that a newer approach to the subject indicated that the dichotomy between a genuine pre-estimate of loss and a penalty was too rigid an approach, and that because a payment on breach may not be a genuine pre-estimate of loss did not mean that it necessarily had to be penal, especially where the clause was commercially justified. The importance of penalty clauses in the strict sense is much reduced by the ease with which similar results can be achieved by other unobjectionable devices. Remoteness. Even if the claimant establishes that his loss was caused by the defendant's breach, damages cannot be recovered for this loss where the loss is held to be too remote. See Hadley v. Baxendale from 1854. It is sometimes said that there are two limbs to the test of remoteness in Hadley v. Baxendale. The first limb, that is to say the first way in which damages will be foreseeable, is those damages which may reasonably be considered as arising naturally, those damages which arise in the usual course of things as a probable result of the breach of contract. See South Australia Asset Management versus York Montague from 1997. The second limb deals with a situation where there are exceptional circumstances. In this case, the damages will only be recoverable, that is to say they will not be too remote, if the special circumstances are reasonably within the contemplation of the parties at the time they made the contract, as likely to occur if the contract is breached. See Jackson v. Royal Bank of Scotland for 2005. Mitigation. There are two elements to the duty to mitigate. First, to avoid increasing loss, and secondly, to act reasonably to reduce it. The basic duty is stated by Viscount Haldane in British Westinghouse from 1912. The fundamental basis is thus compensation for pecuniary loss naturally flowing from the breach. But this first principle is qualified by a second, which imposes on a plaintiff the duty of taking all reasonable steps to mitigate the loss consequent on the breach, and debars him from claiming any part of the damage which is due to his neglect to take such steps. Non-financial losses, that is to say, loss caused by anxiety, mental distress and hurt feelings, are not normally compensatable. This is an area where the position of the law is changing, although the extent of the change is as yet difficult to ascertain. The House of Lords held in Addis v. Gramophone in 1909 that injured feelings were not compensable for a breach of contract. Non-financial losses could be compensated only where the purpose of the contract was to provide pleasure, as in Jarvis v. Swan Tours in 1973, and Jackson v. Horizon Holidays from 1975, or if the purpose of the contract was to alleviate distress. Raxley Electronics v. Forsyth in 1996 recognized that damages were available for a loss of amenity. In Johnson v. Unisys in 2001, the House of Lords held that Addison Gramophone did not prevent recovery in circumstances where the claim was based on breach of an implied term of trust and confidence in the contract. In Farley v. Skinner in 2001, the House of Lords held that damages for non-pecuniary losses would be allowed for a breach of contract where a major or important object of the contract was to give pleasure, relaxation, or peace of mind.